Hello, everyone. It's great to see so many folks on the call tonight. Welcome, and a special welcome to Lisa Blatt, and we'll get to hear a little bit more about her in just a moment. I want to welcome everyone to tonight's Slifka Center online salon. My name is Henry Kohn. I'm the executive director of the Slifka Center for Jewish Life at Yale, and I'm joined as always by my colleague, Rabbi Jason Rubenstein, the Howard M. Holtzman Jewish chaplain, who will act as the moderator for tonight's session with our special guest and, of course, current Yale parent, Lisa Blatt. Rabbi Jason and I arrived at Yale just by way of introduction about 2 years ago, and we feel really honored to lead the Slifka Center, which offers so much to the 1,400 Jewish undergraduates and graduate students who, in normal circumstances, would be leaving campus right now for the summer break. These are not, of course, however, normal circumstances. As soon as the pandemic hit, we built new ways of supporting students and moved our existing programs online. And that's part of how the Slifka Online Salons came to be. This is the fourth such salon to date, and we're so glad to share it with you via this online forum. Lisa was going to come to campus and speak with students, and the fact that we're able to invite all of you to join us as well is a lovely addition. While there's so many challenges in this new environment, we're so pleased to take this opportunity to share the value and products that we share with students every day with all of you, alumni, parents, and friends. So our past salons, our first one featured Yale College Dean Marvin Chun, who spoke about belonging at Yale in a time of rising hatred and anti-Semitism. The Slifka Center's three rabbis shared ideas right before Passover for Passover Seders in a new kind of exile that was represented this year. And just a couple of weeks ago, Yale philosophy professor and Slifka fellow Shelley Kagan spoke about ethical issues stemming from and surrounding the pandemic. I want you to mark your calendars for May 25th, which is the date of our next salon. We'll be hearing from David Makovsky of the Washington Institute for Near East Policy, and he'll be speaking about Israel and American Judaism, blessings and challenges. So mark your calendars for that. And as always, recordings of these presentations can be accessed on our website anytime, slifkacenter.org, using the Slifka Online Salon link. Finally, by way of introduction, I want to acknowledge the Henry Kohn Lecture Fund at Slifka Center for its support of tonight's program. Henry, of blessed memory, set up the fund in the year 2000 to give back to Yale, which he felt gave him so much. The purpose of the fund is to bring students into contact with prominent leaders and influencers of their day. When I shared the plan for tonight's program with Henry's grandson, Professor Adam Dombey, he said that Lisa Blatt is exactly the kind of person his grandfather would have loved to bring to the students through the fund. So thank you to Adam and the entire Kohn family. So as I mentioned, tonight we're joined by Lisa Blatt. She and her husband, David, Yale, class of 85, law school of 88, are the parent of two current undergrads, Daniel and Rachel, and is part of a distinguished Yale family. Lisa's late father-in-law is Emeritus Professor Sidney Blatt, who was well-respected and a beloved member of Yale's psychology department for many years. So just before I hand this over to Rabbi Jason to formally introduce Lisa and kick off the program, just a reminder of a couple of Slifka Online Salon general guidelines. Please submit your questions to Rabbi Jason through the chat function, which you can find along the bottom of your Zoom screen. Rabbi Jason will moderate and may occasionally call on participants in turn to pose questions. When you are called upon, please introduce yourself with your Yale or Slifka Center affiliation, class, year, friend, whatever it is. And then in one succinct sentence, please pose your question. Please help us keep things moving and get to more questions since we have limited time. We want to let you know again that this session is being recorded and will be available on our website. And also want to point your attention to a quick 3-minute survey for this evening's program, as well as the couple of others we've had recently. The link will be available in the chat box, and you'll see it in other places. So we're excited to share these salons with all of you in keeping with Slifka Center's goals, to explore the intersection of what is Jewish, American, and Yale in our constantly changing world. Now over to Rabbi Jason.
Uri, thank you for that lovely introduction. And Lisa, it's just wonderful to have you here. Who is this? Who is our star guest tonight? Lisa Blatt serves as the chair of Williams and Connolly's Supreme Court and Appellate Practice. Ms. Blatt has argued 40 cases before the United States Supreme Court, more than any other woman, and prevailed in 36 with 2 pending. She was also selected to be among the first lawyers in the court's history to present telephonic arguments just a week ago Monday. The National Law Journal has called her a visionary and one of the 100 most influential lawyers in America. Bloomberg has described her as a legendary high court litigator, and the National Journal has referred to her as a SCOTUS legend. Ms. Blatt is also a visiting professor at Yale this term, and as already mentioned, the mother of 2 current undergraduates. And I want to say personally, it's rare to see students get as excited about having a chance to interact with someone as they have with you, Lisa. I even got an unsolicited email from a recent YLS alum who said, Lisa Blatt is the best. I'm so happy she's coming. Like, one of my most memorable classes in law school is when she dropped in for a guest session. So, and just, it's been really exciting to plan this session for you, to hear everything about the ways that you've made being a woman at the top of the legal profession a part of your public persona, the way that you have kind of very interpersonal relationships with every member of the court and the different factions, the way that you're really a part of this venerable tradition, updating to modernity and digital life in a way that feels very resonant with what synagogues and Jewish institutions are dealing with, to the specific religious content on the court's docket, which you really put on my radar screen. I'm looking forward to us learning more about the significance of that this term. And then you should all know that the reason this event is tonight and not last night is because Lisa said, well, when we were planning the date, well, Tuesday the 12th is when the arguments about the Trump tax returns are going to be before the court. Like, you want to have the event after that so I can offer some real-time color commentary. So stay for that part, and all the way through the end. There's going to be a survey. And I also want to say,
survey. Say nice things, please.
For those of you who don't have a lot of experience with Zoom, part of the fun in Zoom is the chat. There's really 2 conversations going on. So you should feel free to really make this a conversation over the chat. You can respond to people's questions, and that document gets saved. And actually, historians are collecting these things as ephemera right now to write the history of this time. But it really can be a lovely and lively place. You can't bring everyone's voices in an auditory way, but you can actually kind of follow along and contribute. And I will be monitoring that chat. You can send chats privately to me, privately to others, or to the whole group. And with that, Lisa, we're all yours. And after you finish your opening gambit, I'll collect the questions that are in the chat window by that point, and select 1 or 2 to send to you as the first batch.
Okay, thank you so much. I'm so glad to be here. I don't have my glasses on, but I can see some of the questions floating up about Justice Ginsburg dying. So this is going to be fun to get your questions. I cannot wait, and I love as many off-ball questions as you want to give me. So thank you for the introduction. I guess you now understand why I'm here, but I actually didn't go to Yale. I went to the University of Texas, both undergrad and law school. But in my first job, I met my now husband, who grew up in Woodbridge, and his dad, Sidney Blatt, had been a professor, I guess then maybe 40 years, but he was a professor there for 54 years. So Woodbridge and Yale has been, I guess, my husband's life. His mother worked at Yale in development, and his sisters went to Yale, and both my kids are at Yale. But I first fell in love with Yale when the then master at Jonathan Edwards asked me to do a master's tea, and I met the students, and I was like, okay, yeah, it was very special. And this spring, I probably had my most rewarding experience of my life teaching a class with David Cole, who's JE and law school grad, and head of the ACLU's, the legal director for the ACLU. And we just had a wonderful time. Okay, so that by way of my Yale background. I had my first Supreme Court argument in 1996, and I just finished my 40th argument on Monday, which was the first live argument and the first argument by telephone. I served under, I think, 6, maybe 7 solicitor generals and acting solicitor generals, starting with the Clinton administration, and then I left in the Obama administration. So I was there for 13 years, and I've probably watched, listened to, or read the transcript for over 1,000 arguments. So I definitely consider myself a watcher of the court. I thought I would give you just a brief to sort of provoke a conversation, tell you some just thoughts that I have, both retrospectively and then the current court. And I think I see Linda Greenhouse here, so I'm very nervous that I hope I meet her, you know, expectations. When I started practicing, it was the old Chief's Court. It was Justice Rehnquist, and it was a different court. What I would call the federalism court. It was a court where Justice O'Connor was the swing justice, and it was states' rights moved to the court. I've seen it then go to the new chief court, and the swing justice become Justice Kennedy. And now, you know, there's a debate about whether it's the Chief Justice or Justice Kavanaugh. But what I would like to sort of offer up this observation that it has gone from a court about federalism to a court about religion. And I don't think that this topic has been given that much attention, but I have never seen the court this focused on religious liberty cases. And we'll talk about that. I like to think of the court, and I've said this many times, as they're an old married couple. They're married, and so they pick their battles and they get used to each other. And I felt like that was absolutely true up until recently. I don't feel like I can say that. They don't strike me as an old married couple anymore. It seems very unstable. And I think that not with Justice Kavanaugh. I think it started with the arrival of Justice Gorsuch. And so I still think the court is in transition, and maybe they're not going to be like, I just don't know, because right now, I think you all think of them as the 5-4 alliances with the conservatives, the 5 more conservative leaning and the 4 more liberal leaning. But the alliances aren't like what you think they are, at least in terms of the big ticket items. I would say abortion, guns, race, and LGBT rights. Yeah, you can fight for them. But there's so many cases at the margins on all of these areas that there's so much room for shifting of alliances and you know, trade-offs. And so I think it's a hard court to call right now, and much more unstable than people think it is. I would say I have marked down 3 things to start it off with. I would say the hottest items that I think is on the court's mind. The first is approach to stare decisis, and for the non-lawyers, that just means adherence to precedent, respect for the decision as it stands. And most people think, okay, Roe versus Wade, that's what we're talking about. And I think we're talking about way more than Roe. They are obsessed with when should they overrule one of their cases. And it has been coming up in the criminal law. It's been coming up in administrative law. It came up in a big way with a very important case about the rights of union employees. And it's coming up in the area of reproductive, you know, freedom, or whatever you want to call it. You could also call it, you know, religious liberty, depending on your perspective. But I feel like they all are trying to take a stand. And I don't think it's for the public. I think this is an internal debate that they're having. I think that they care so deeply about this issue, and they seem to be going out of their way to talk about stare decisis more than any other topic. The second thing I think that is sort of a big controversy at the court, and that is how much public opinion matters. We used to call this the Linda Greenhouse effect. I don't remember, but she's on, but how would this be portrayed in the New York Times? She covered the court for the New York Times, and now Adam Liptak does. And in my view, and I think most people would agree, the Trump dogma for picking judicial appointees is to make sure that public opinion is irrelevant, that you are steeled and don't, you know, committed. And I think even Justice Scalia would have been considered not reliable. And so it is very much a different type of judicial appointee now that can't be changed, won't get liberal with age. And so it's a different type of judicial decision-making. And then there are those who feel like maybe they're movable because of public opinion, like the chief. And this has come up in sort of the areas that you know about, Obamacare, the census case. and then maybe DACA, the Dreamers. But there's been a lot of cases of huge public importance, and maybe Obamacare. And we could talk about Bush versus Gore maybe being another, but how much do they care? And there are certain justices that care, and I think certain that don't. And then the final one is what Jason talked about, and that's how the court is now, I think, more than any other issue, they care about religion. The reason why this is so important is there are more than just institutions of sort of religious faith and a synagogue, a church, a mosque. There are so many religious affiliated institutions. You know, Georgetown University, Catholic school, charities, hospitals. I think a third, some enormous amount of hospitals are either or religiously affiliated. And so we have so many, gymnasiums, community centers. And sort of like the days of the ACLU, think Justice Ginsburg, or the NAACP, think Justice Marshall, there are groups now that Beckett, I don't know if it's Beckett Fund for Religious Liberty and the Alliance Defending Freedom, have been very effective at picking cases and bringing them to the court and getting results that are great, depending on your perspective. But if you believe that, you know, religious should be more part of public life, and you know, very pro free exercise claims, they've been doing a very successful job, and they've been quite brilliant in the way they pick cases and are bringing them to the court. So this term alone, well, let me just back up. I think the last big religion case, and all these cases, I think that they all have public relevance. There was the case in Colorado of the Colorado baker who didn't want to make a cake for a same-sex wedding, and the court couldn't reach a decision on First Amendment grounds, but they voted for the baker on sort of on the basis that the state Colorado officials had acted out of animus for religious liberty. That was a big case. Just this term, we just had an argument about whether the president's exemption for the requirement that employers provide birth control to women, whether there should be an exemption to not just religious institutions, but religious affiliated institutions. The Obama administration kind of went all over the map, and then this has been up to the court, I think, 3 times. So this is the 3rd time, and the Trump administration has sort of the broadest exemption, and states have challenged that. The other, there was another case about out of Montana about aid to religious schools, and these come up all the time. And I think you also see in a lot of cases come up about, can you have crosses on highways and stuff like that? So those come up a lot, but we had another one with a giant cross in Maryland. But I would say there were 2 more big ones. This is a case that was just argued, I think, yesterday. It's called Our Lady of Guadalupe School. And it has to do, and I'm trying to lower this so you don't have to be a lawyer, but generally it is assumed that no one can tell a church or a mosque or a synagogue how to hire and fire their ministers. That is completely sacrosanct, and it would be a violation of church and state for the courts to ever review that. So if you want to discriminate because you don't like the person, because of their race, it doesn't matter. But what about the janitor? What about the, and in this case, what about a teacher who may or may not be that religious, may not be the faith of the school, but engages in religious instruction, even maybe walking the kids to religious services? Are those people, can they be hired and fired? And here, I think the woman was fired allegedly because she had breast cancer. And I don't know what I think it's a school said courts can't look at that under Title VII employment discrimination laws. So it's how broad is that exception? How far beyond the minister does the exception go? And then for you real legal nerds, there is the big one next term. And it could turn out to be nothing. But generally speaking, religious organizations have to follow generally applicable law. They have to forget the religious thing I just talked about, but generally they have to follow Title VII, health and safety laws, non-discrimination laws. And that comes from, I don't know if it was in 1990, it may have been 1980. It is one of Justice Scalia's most notable opinions, Employment Division versus Smith, that says, yes, religious organizations have to follow facially neutral laws. And that a religious charity is seeking to have that decision overruled next term. I think it was, I'm not sure which state, oh, it's the city of Philadelphia said, we don't want to enter into a contract with you unless you sign our requirement that you don't discriminate, which applies to everybody, anyone they contract with. And the religious organization is saying that's unconstitutional and you should overrule that precedent. It's a very big issue if they overrule it, but we'll see. And I think the reason this religious issue does become so important is it bleeds over into other areas. Whether Title VII applies to transgender status and same-sex education, those are generally employers who have religious objections. Most people don't say, you know, they're just hostile to transgender people. They're saying they're, you know, it's religion. And so why? Catholics make up 24% of the population, but 2/3 of the court. Roberts, Thomas, Alito, Sotomayor, and Kavanaugh are all Catholic. Justice Gorsuch was raised Catholic. Apparently he's, I think, goes to the Episcopal Church, but people wonder if he's still Catholic. Justice Kennedy was Catholic, and then the remaining 3 are Jewish, Ginsburg, Breyer, and Kagan. So you have like all Catholics and 3 Jews. So I don't know if that matters, but I think a combination of the justices being Catholic and these religious organizations being very smart, very focused, very organized, and sort of very good about picking their cases is the reason we see those cases. So with all that, I will end, and hopefully that gave you enough of an overview of what I think.
Great. So we are not going to want for topics or energy here. I want to hear, Slate has this great podcast called The Working, where they just hear what people's jobs are like. And could you just start off telling us what it's like to stand up there in the Supreme Court, the justices in front of you, and make an argument and then respond to their questions, and just what it feels like, how it's different than other courts, how it's changed over time. It's like, none of us on this call will ever get that experience, and I want a window into what it's like.
So I think I'm a unique advocate because I'm very blunt, direct, and informal. And I don't know why that is. It's just the way I am. But I'm always nervous. I always feel sick afterwards, and I always regret half of what I said. And I always feel like quitting the practice of law when I'm done. But you prepare a lot. And I think if you prepare enough, once the questions start coming, you know, the answers start flowing. And I'm always driven by, you keep your credibility intact, but all that matters is winning. And so you're just trying to tell them why they need to vote for your client. And that's, you know, that's what matters. As a decision maker and you're advocating, I don't think of the Supreme Court as how to move the law. I think of it as how to win that particular case, as opposed to what should the law be and how to move the law in a specific direction. I'm very old school that, you know, the lawyer is there to protect the client. Client's interest.
That's so interesting. So even though a client isn't physically present, they're very much at the center of your orientation.
Sometimes they're present, but you know, I humanize every client, whether it's, and I've had some pretty controversial clients. You know, I have done amicus work for veterans groups, criminal defendants, and the ACLU, but I represent tobacco and steel companies and oil companies and, you know, the Washington Redskins, all with great zeal and excitement and passion. So you know, I remember talking with the Yale kids about this. How can you you know, be so liberal and represent with such glee the type of representation? And I remember I'd had a race discrimination case. I think I had a pollution case, and I forgot I had some other horrible case. And I saw Justice Kagan at Claire's, you know, at Yale. And I think I was up there for my father-in-law's funeral or for one of these receptions. And I told her, what am I doing? I mean, how did I get like this? And she said, you know, this is what you wanted to do, and these people need representation. But I like it.
Great. So great. So I want to turn to our first audience member. It's not just any audience member. He's a lawyer and the chair of the Slifka board, Evan Farber. Evan, I just unmuted you. He's got a pair of questions here.
Sure.
about recent events at the court.
I think, so apparently not this case, but my last case is a couple on Howard and Jody Hello. So I have a New Haven or Woodbridge client that's watching. So hi there. Okay, go ahead.
Okay, thank you very, very much for speaking to us tonight. I really appreciate it, and it's been fascinating so far. I'd love to hear how your video argument experience differed, if at all, from your regular arguing. Since it was sort of our appetite was whetted in the introduction, I'd love to hear your reactions to today's arguments as well.
The video argument was it was a telephone argument, extremely stressful, unnecessarily so, but there was so much difficulty with the technology and worrying about whether my landline would work and how to deal with the dog and my 21-year-old son and my daughter and my husband. And where to do it. We went through 3 podiums. My husband broke 2, and one of them kind of hit the wall on our stairs. So I don't know when we'll ever get that fixed. But like these silly little things took up an enormous amount of emotional energy. The argument itself, I don't know if I was a little more edgier than my normal self. I think I was just me. It helps that I had know them and could picture them. I definitely pictured the 9 of them speaking to me, and I think it made it somewhat familiar, but I missed seeing them. Generally, you didn't ask this, but generally I think the whole process has gone very well. I think that they should do live arguments. It's way more fun listening to them live than nobody wants to listen to them on Friday or the week later. It's like, who cares? You've already read 10 reports about them, and no one is going to do that. And this way, I think it's great that they're doing them live. I think the justices have been very well behaved. The rock star has been Justice Thomas, because he's finally speaking and everyone is getting a glimpse into his mind and seeing that he is just really on top of every case. I think he and Justice Kagan have the best telephone voice. They're very crisp, they're very concise, and they just have great telephone voices. Today's argument. I've been reading George Conway. I've been texting with George Conway and trying to read his Twitter feed and talking to conservatives and liberals and I think that a lot of people have a lot of different views about today's arguments. The most I can tell is that the case where the state prosecutor is seeking Trump's tax returns in connection with a grand jury investigation went better for the state than the case where the House is seeking him. Why that is really complicated, and it may be that we don't know. I think Justice Kagan was talking to the chief with a couple of her questions, so I assume the chief is in play for the House, but I don't know. But I think I can say with somewhat confidently that the case went better for the state, the Manhattan DA's office, Vance. But it was the typical justices. They were very much the same, the way they always are on these presidential cases. And in this kind of case, these are cases where I don't think oral argument matters that much. These are too big, just too important and too big that they didn't need to have argument. They know they're going to figure it out what they want to do.
Thank you. That's fascinating. Thank you.
In terms of cases on the court's docket, we have a question from Saul Roselar, who's an undergrad, and a big fan about stare decisis and some recent kind of proxies, perhaps, for Roe v. Wade. So, Saul, would you pose the question? I've unmuted you here, and then we'll get into some of the weeds.
Hi.
Sure. Hello. Thank you so much for coming and doing this. Yeah. So I saw the recent case. I believe it was Ramos versus Louisiana, and it was about unanimity for juries. And there was an op-ed in the New York Times that alleged that I think there were 4 different decisions that came out of it. And it alleged that, as you sort of said in the beginning, that justices were using this to indicate where they stood on precedent. Do you have sort of further insights into that on that
So
case?
it's more than just Ramos. It's been a lot of cases. There have been so many cases that have produced, the justices don't like to issue a lot of splinter decisions, but it's been nutty. I mean, there's been so many separate decisions that I think supports the notion that the court is not as stable as people might think. Justice Kagan went out of her way to vote with Justice Alito and I forgot who else. And I think that there was a very extensive article in the New York Times about this. And I think she is, some of us would say, you know, you go, she's trying to stand on principle. And I think she's hoping that if she can say, I'm going to respect precedent, that some other justices will respect precedent. Justice Ginsburg, I think, probably has my view on stare decisis, which is if I don't like the case, I'm going to overrule it. I think but other justices sort of want to have a theory on when you should respect precedent. And I think that this is not doable. I know that Justice Kavanaugh wrote a whole thing about stare decisis, and I read it thinking, okay, I know nothing. I can't tell what he meant by it, except that he must have a lot of time on his hands during COVID, that he wrote a whole law review article on stare decisis. It was very well done. But what they're upset about, I assume, is this abortion case that's on this term. A Texas law, the court 5-4, had said that Texas was not acting lawfully in putting all these crazy requirements on these medical facilities that were obviously directed at restricting the rights to women, and they were pretextual. And Justice Thomas wrote a very scathing dissent saying the court goes out of its way in abortion cases to apply a different law. And so I think that this is a big, there are certain justices who are very angry about its whole women's health, and Louisiana basically passed the same law. The Fifth Circuit basically said, well, that case was decided on a Monday. This case is decided on a Tuesday. And so we'll see if the justices are going to say it's different enough. I think it's Louisiana law, or they're going to try to say this is just like the Texas case. Again, this is sort of what I meant by, I don't think any of the justices want to deal with whether Roe versus Wade should be overruled. They don't. Some of them might. There may be 3 of them. But most of them don't. But there are just a lot of cases at the margin. I mean, states are trying to restrict it in its most restrictive possible to bring up a case where the court will have to confront the issue. But I think the court very much wants to avoid the issue.
Thank you.
Great. You mentioned that Linda Greenhouse, the legendary court reporter and member of the YLS faculty, is here on the call. So Linda, I wanted to turn things over to you. Is there any theme you wanted to raise up, or any questions you've been wondering what Lisa Blatt thinks about, and now you get to ask her in front of 158 onlookers?
Well, it's a pleasure to be in conversation with Lisa. Actually, I agree with everything she has said so far. I really commend her because, at least in my experience, very active Supreme Court advocates who stand before the court a lot, when they speak in public, they tend to pull their punches a little bit. They're afraid of, offending this justice or that justice. But with Lisa Blatt, what you see is what you get. She tells it like she understands it, and she understands it.
I don't think they mind, Linda. I really don't.
So, on the topic of today, the religion cases, I just want to make one more observation. Lisa's exactly right. I mean, this really is a court about religion. Now, why is it a court about religion? I think the religion cases are, at least to some substantial measure, a displacement for the battle over LGBT rights and same-sex marriage and the role of women in society and all of that. And, there's no going back. There's no way the court's going to reverse itself on same-sex marriage. There's no way, women are, I was about to say back in the kitchen. I feel like I've been in the kitchen every night since this lockdown started. But seriously, so they can't fight the kind of big billboard issues. So they're trying to find religious carve-outs from what I regard as the essence of civil society. That is to say, society is built on the assumption that the law applies to everybody. And that was Justice Scalia's, I think, brilliant decision back in 1989-90, in employment division against Smith. I'm one of the few, I think, liberals who thinks that that case was rightly decided because it says if there's a neutral law of general applicability, you follow it. And, you know, it really doesn't matter unless you can show that the government has singled out your religious practice for a special burden, or you can show some special situation. So now we've come to the kind of reductio ad absurdum of this. So Congress purported to overturn employment division against Smith. Now that's very hard to do because it's a constitutional holding, and it's an interpretation of the First Amendment. Congress doesn't have the constitutional right to overturn a Supreme Court decision. So they made this workaround, the Religious Freedom Restoration Act, which has metastasized and has become what was meant to be kind of a shield against religious discrimination, has become a sword in the hands of the empowered religious right, where anytime the government tries to apply a rule to them, the Religious Freedom Restoration Act says you can't do that. So that's the case that Lisa alluded to that was argued last week, the so-called Little Sisters of the Poor case, where employers, the Little Sisters of the Poor, that sounds like a group of nuns, and they are, but what they do is they run nursing homes. They're equal opportunity employers. You don't have to be a nun or a Catholic or any religion to work there. And of course, the same thing to be served by them. And they're claiming an absolute opt-out from having to follow the Affordable Care Act and include contraception coverage on their employee health plan, which is what the ACA, Obamacare, requires them to do. And you know, that's what the court has to decide. And you know, chances are they're going to decide it the wrong way, and then we have another tear in the fabric of civil society in the name of religion. But it's really a kind of third-party harm. The people who work there don't have a religious stake in it, and the court seems, the narrow majority seems oblivious to the fact that there are third-party individuals who have a legal entitlement to this coverage, and they're not going to get it because of some very attenuated complicity claim that's being raised up by the religious employers. I think it's pretty tragic, actually.
So I could respond to some of that. I mean, the one thing that I like to say to people, well, I'm still waiting for what happens if RBG goes, but I am extremely liberal, but you know, having represented a bunch of Catholic hospitals, it's great to have religion on your side. They're just so, it's just, you know, they have a lot of power of persuasion. Roe itself is a made up right. It just kind of came out of nowhere because Justice Blackmun studied at the Mayo Clinic.
Oh, I don't agree with that.
Of course you don't, and that's fine, but it's certainly, no one tries to support that decision. I'm all for the court making up rights. I think it's a great thing when they do it, as long as I like the right and I don't mind admitting it, and think the court should keep protecting Roe. But it is a hard argument for liberals to make, is all I'm saying, just judicially. All right, so next question.
Okay, so you brought up RBG. Nathan Heilwell had a fascinating question about you clerked for RBG, you argued before, and I just tell it. But Nathan, I want you to ask the question about just this, you know, the kind of your perspective on her last 3 decades as a justice.
About her for a long time. I remember when, I don't know if it was her 30th year, or maybe it was her 10th year anniversary, I was lucky enough to get to toast her. And oh my God, it was a bunch of academic intellectuals talking about, I don't know what it was. And I was not gonna do that. So I roasted her and did, you know, a complete, like totally roasting her. And it was only when she started cracking up did I get the audience laughing. But it was so much fun because everyone likes to think of her as this civil rights lawyer and this champion of women's rights. And all I remember is she was a difficult boss, and the only thing we could connect on was fashion and clothes. And she, we used to talk about jewelry and shoes and all her, funky outfits and shopping. So that was my currency with her. And it always has been. We don't really talk about the law very much. I think of her as a girly girl, but she is a powerhouse. I think the whole notorious RBG thing has overtaken her life in a good way since her husband passed away. She was under a lot of criticism for not resigning in enough time for Obama to replace her. And I think that we're all trying to wrap her up in bubble wrap and not have her extend herself. But she wants to live her life. Fortunately, COVID has kept her from traveling and doing speeches and jumping out of planes and whatever else crazy stuff she wants to do. But she wants to continue to have a full life. And I think the rest of us just want her to eat kale and stay alive. So, I mean, I think she's great. She's a tough boss though. She's hard. She's very into detail. So she's very fastidious and super demanding, but lovable. And I just have a wonderful relationship with her. She's always been so supportive. She does not mind my, I would say, sassiness. I think she thinks it's probably entertaining. So, and she's given me some key advice throughout my career. So, yeah, I care about her very much.
I love getting that personal angle. You can't get that anywhere else. We've got a question from Yishai Schwartz actually about Supreme Court reporting. Yishai, would you share about present company, but also others? So Yishai, what are you wanting to ask Lisa?
Sure, thank you so much. I guess my question is, it seems like we've gone from like Anthony Lewis in the old days and now Linda Greenhouse and I don't know, Nina Totenberg, who were fairly respectful of the court in their reporting. And now we have some people, I think the preeminent example is, I guess, Dahlia Lithwick, who's not respectful of the court in her reporting, at least personally, I would say. I mean, maybe she's very respectful of them in person. Yeah. And I guess I'm curious of your take as somebody who's both blunt, but also somebody who my impression is actually likes the justices and has decent relationships with them in person. What you think of this movement from this more respectful, I would say, substantive analysis and reporting to a more partisan, chatty, personal.
I think it's just the age of the internet and Twitter and that kind of thing. I cried when all of them have resigned. I was really, really taken aback by Justice Scalia's death, and I don't think I agreed with much of what he wrote. So yes, I think that anyone who appears before them loves them and loves the court. The reporting, I think, got a little, bad, I think, with Justice Kavanaugh. Maybe that was Dahlia Lithwick. What I think is more important, and I know that the justices, at least a couple of them, were horrified that I said this. I'm all for court packing. So everyone says it's a horrible idea, and I would lose any debate. But the mere threat of court packing has, the court thinking we better behave, we better not go completely overboard. So at least we should have that discussion. But just to say, let's discuss court packing. It's not to say you don't like the court. I love the court, but we can all be open and honest about what happened with Judge Garland and what it means. The liberals weren't entitled to have Justice Scalia die, but they were certainly entitled to have, Garland voted on. So I think you can be very respectful, but still have a frank conversation about the confirmation process, whether the court's polarized. I don't think there's any debate about Mitch McConnell's ambitions and the president's pattern of appointing justices. It's not critical. If you are conservative, it's a good thing. It's a great thing. You're getting your party's needs met. Obama did a great job appointing Justices Kagan and Sotomayor. They've been terrific for the Democratic Party. And the last administration did a great job with the Chief and Justice Alito. I think you can talk about all this stuff and still be respectful.
Linda has her hand up. Yes, as the Supreme Courter, the reigning one in the room.
Yeah, I think the question reflected a kind of a category error, actually. I mean, Dahlia Lithwick is an opinion writer. She writes an opinion column for Slate. She's not purporting to give dispassionate, daily journalism about the court. And we've always had opinion writers about the court. Anthony Lewis covered the court as a journalist for 7 years and then wrote about the court as an opinion columnist for the next 35 or 40 years. And he was, as the court turned to the right, was very critical of the court. So I'm not, maybe I didn't understand the question.
Your typical, the Supreme Court press corps is amazing. It's a cooperative group, wonderful. They're all very objective, very dispassionate. They're all very friendly. And yes, I think Linda's right. They love the court and they are very, very objective and great journalism. But I'm just saying with the advent of the internet, you do get a lot of just opinions and organization. I don't know, there's one, Fix the Court. I mean, there's all kinds of groups that are critical of the court. But yeah, they're not purporting, I don't think, to be journalists on sort of the Supreme Court core that's covering the court's docket as sort of, just reporting to the public. So I think that
I'll just say one more thing. So I wrote that column about the Ramos case that somebody mentioned early on. And I think the headline on it was something like the Supreme Court in crisis. And I said exactly what Lisa said, that, this opinion revealed deep instability and kind of clashing agendas that had very little to do with actually the question at hand. And that was an opinion column. Would I have written that back in the day when I was writing the daily Supreme Court story? I certainly would have. I mean, I would have had that understanding, I think, but I would have found a less, sort of aggressive way of expressing myself, I'm pretty sure. Or my editors would have found a less aggressive way for me to express myself.
Right. We have a question now about professional ethics from Simon Rice, who's a law professor in Australia. Simon, you're unmuted.
Professional ethics. Oy, okay.
Be warned. Hello. Yeah, I'm in Sydney, Australia. I knew about this because I've had 3 children at Yale, and so I get the Slifka Center emails. And when I got it, I forwarded this to colleagues. So I hope there are some Australians listening to you, Lisa, here. I'm actually teaching this semester. I'm Zoom teaching, as we all are. I'm teaching both legal ethics and public interest. And from a distance, the US Supreme Court is in a league of its own as a political organ, something we're not familiar with here. So the question here is, it doesn't really arise in Australia with nearly the same pointedness as it might there. I'm interested in the stance you take. I've no doubt you're an absolutely zealous advocate for your client, whoever they may be, before the court. But that makes me wonder, do you exercise choice in briefs you take and clients you represent? Do you take on anyone and zealously advocate on either side of a cause, or do you have your own preferences?
Sure. I think let me just tell you the cases I've turned down. I've turned down a bail bondsman. I was like, no thanks. That was like, no. And I turned down a case when I was in government that was against a doctor who wanted to advise their patients about medicinal use of marijuana. So, and I turned down a sexual assault one not because I felt it was a famous one, and I just felt like I couldn't do it because I just felt so like it was too consequential and I couldn't emotionally take it because, I have a son and it was just too hard. But that's it. I think that other than that, sure.
Okay.
I haven't had clients call me up and say, will you do something crazy? These are companies. You wouldn't want to law. I mean, this is what I tell law students. When someone asked me, it was a Yale thing. Someone asked me, do you ever, what do you do if you don't think your client is right? And I went through the roof. Client is always right. What if this was your mom or your son in legal trouble? Or what if someone wanted to take away your house or your property? You have a story, you're entitled to your rights, or criminal defendant. I mean,
yeah,
you have a right to, but no, if I couldn't feel like that and couldn't want to sort of throw myself in front of a train for the client, no, I wouldn't take it on. But I think the bail bondsman maybe was the last time that happened.
Okay, so yeah.
No, thanks.
No, what you're saying is what I teach in ethics class, and at the same time I'm talking to public interest students who can't bring themselves to think that they would advocate for a whole class of clients. And
I think young people are a little, I don't know, a little spoiled. I represented the Washington Redskins, probably the best case I've ever had. I was born to do that case. I just loved everything about it.
Thank you.
Great. I want to call on actually my teacher, Josh Kahan, Yale alum, here with a question, really fascinating question about the significance of arguments and the kind of the life of a case before the court. Josh, take it away.
Okay.
Thanks so much, Jason, and thanks. It's a real pleasure. I would find myself wondering especially when the major cases come before the court, as a lawyer arguing those cases, do you feel like you always have the power to sort of win the day or sway the case, or do many of those cases feel like the justices are coming in with their minds made up, and like there's no way you can impact it? And to the extent that you can't, how does that change your experience arguing?
So, I think the justices always have an open mind. I think every judge does, or at least they think they do. Why not? I mean, it would be weird. I hope that they're a judge because they want to hear both sides. And these are all such intellectual nerds. They're so nerdy that, they get into it. They want to know. I think they want to engage on every case. I think the way I function is I have to think the lawyer can make a difference. And but sure, I'm positive there are unwinnable cases. I think the two cases I lost 9-0. I thought they were winnable, but I guess I was wrong. But yeah, you always try to shape every case. Again, my approach is a little different. I think some people are more doctrinal about the law, and I'm a little more, let me try to fight on the equities and use the law that way. But the justices are pretty used to a set formula on how they like their briefs. And so you try to, and in the same way with the Court of Appeals or state courts, you make the legal arguments, but yeah, you're always trying to create a narrative and a story that there's a real reason you should win.
And do you find that when decisions come down, they really reflect, are they judging the case on the legal questions that you put center, or do they do they find their own kind of bases for?
Again, I think what I was saying is that other than a pure case on should there be a Second Amendment right to bear arms, should Roe be overturned, is affirmative action unconstitutional, I'm not sure the lawyering makes a difference. I could maybe name 3 other types of areas, but everything else I think is up for grabs. I think everything else is up for grabs. Maybe we could try to see if lawyers could persuade on should Roe versus Wade be overruled. You would try to frame the argument about reliance. And if you were on the other side, you would try to frame it up about let the states decide and the role of courts. But I think they could probably figure that out on their own. So yeah, and there would probably be 400 amicus briefs. So I do think there are just a few cases where the justices are very confident in what they think. Although apparently when they testify, they've never thought about any of these issues in their confirmation hearing. What's Roe? But everything else is up for grabs. That's what I was trying to say in the beginning, that even in the area of all these, even the Second Amendment or LGBT rights, there's always room to shape the case. And I don't think their minds are made up. I don't think so on any of them. Maybe you could think that the most politically, the ones that you would claim are the furthest to the right or furthest to the left, their minds are made up, but maybe that's 2 people. The rest of them are up for grabs. I like to think all 9 of them are. Otherwise, what's the point? Might as well throw in the towel. And this has always been surprising. I think if you, the conventional wisdom and the talking heads of all last term said that every justice on the right, with the exception of Justice Alito, sided with the liberals. So Justice Gorsuch sided with the four liberals in a couple cases. Justice Thomas did it. The Chief did it. And Justice Kavanaugh did it. So the only one who stuck to his guns was Justice Alito. And whether they're doing it because, who knows, there's all kinds of explanations. I like to think that they want to stay relevant. And there's a lot of shifting alliances. They may not be the cases that you hear about, but to them, and I think to the parties, they're important. And there's just, they've been kind of all over the map recently. The voting bloc has been, like I said, it's just unstable.
So I want to close with two questions. The first is, you mentioned the religion of the justices. Would you just speak, you know, you're also a person of religion. What are the kind of points of intersection or tension between your Jewish identity and your work as a legal advocate?
I hope it's okay with the Jewish religion to want to win. I hope. Look, if you're calling a lawyer, you got a problem. You need a legal solution. And I do something where there's a winner and there's a loser. I'm not someone you call to settle a case or to mediate a dispute or to get advice on how do I work through, you know, FDA's regulations. I'm calling because you lost a case or you won a case and you need to defend it. So it's very much a zero-sum game. But I think there are just so many other areas of the law that don't involve that are much more, you know, cooperative and involve a lot of listening and some other skills. But, you know, at least with the Supreme Court and a lot of other things, there's one side wins, one side loses. So I don't thinking about religion when I'm sorry, but I'm not thinking about religion when I'm trying to win. Sorry.
I will say, you may not be thinking about it, but the tension that you just described is actually the kind of the primary debate between the medieval interpreters of a passage in the Talmud about how to set up courts. The way that Jewish courts don't have power of influence, but generally they function as arbitration bodies, and each of the litigants picks one of the judges, and then those two judges pick the third judge. And Rashi, the kind of baseline commentator, says that this is because the litigants need someone to kind of present their case. And then and once you've talked to a litigant for a long time, you can't be impartial anymore. So really the third person is the single judge. And then later on, we get, you know, the 1400s, we get these complaints from rabbis saying that parties are hiring these unscrupulous lawyers who will say anything to advance their client's case. And the thing that really galls him is that they cite Rashi as their defense, right? That this is kind of the mandate. So just that tension is built in.
This is doctrinal, but I do think that, you know, my parents are from New York, and I do think that my sort of colloquial gestalt is definitely, you know, I think at bottom, a lot of the Jewish religion and rabbis, what they are, storytellers, and what we do is tell a story. And I do love that when I'm ever listening to anything involving Judaism, there's always a narrative and there's a story and there's morals and themes. And that's definitely huge. I mean, rhetoric, how you present it, the narrative you're telling, what is the moral that comes from it? That is similar because you're trying to win over the hearts and minds. In your case, either congregants or maybe God, I'm trying to win over, you know, judges. But it's all appealing to a higher authority and the art of storytelling.
Wonderful. I do want to ask just one very last question, which hasn't come up in the chat, but I'm going to exercise my own prerogative here, which is I had a very moving dinner with Aharon Barak when he was at YLS in the fall, and it just produced this movie really about kind of fighting for the place of the judiciary in Israeli politics and kind of Israeli liberal democracy, and the stories about the judiciary in Poland and what's going on in America. And I wonder if you could zoom out, and Linda, you kind of brought this in about what political forces are working on the court, but really is the fracturing on the court a microcosm of the fracturing of American political discourse? And are liberals putting too much stake in the court when they're losing elections? And just how do you see this kind of tension between all of the, the smaller number of swing state districts and just the kind of increased toxicity of the American public sphere. And is the court just kind of swept up in that? Is it a bulwark against it? Is it a weak bulwark? How do you feel those macro forces?
This is where I think the court, it comes back to the old married couple. I mean, they, after one of the most contentious confirmation battles since Clarence Thomas, they all rallied around Justice Kavanaugh. Sotomayor, Justice Ginsburg goes out of her way to compliment him. And so they, close ranks quite quickly. So I do think as an institution, they don't want that. I think the type of shifting of alliances is definitely more doctrinal. It's not straight conservative and liberal. It's sort of how the law should approach. I do think externally, we have a very, I remember it was at a party, a bunch of liberals, and no one could understand why anybody would vote for President Trump. I literally said, have you heard of the Supreme Court? I don't know what, these people were just stupid. They had no conception that the Supreme Court matters to at least conservatives. And they've done a great job, and more power to them. If you're a Republican, your party is getting your needs met. You should be very happy. They've done a very good job at making sure that they're appointing the type of judges that meet their vision of how the judiciary should function, protecting, coming away from the administrative state, minimizing the role of government, and promoting certain individual rights.
Wonderful. Well, Jody summed it up on the chat. She said Lisa Blatt is a rock star for us liberal nerds. I love that mixed metaphor of the rock star. And other people said, I'm not a legal nerd, and she's a rock star to me too. So you have a broad coalition. I want to say a huge thank you to you. Also to, a lot of work goes on behind the scenes here. To my partner, Uri, and we're like a young married couple, the two of us. And also to Jen Wallace, our development director, and Lynn Jackson-Clan, Evan Wexler, Benjamin Laufer, all helped put various pieces of this together. And also I just want to say personally, it is so moving to be able to connect with people familiar and new through this, and really actually constitute a community of inquiry and learning and caring through this chat. It really is one of the times when I feel most kind of connected to my fellow humanity, to the Yale community, to a real community of learning and practice. And Lisa, you really represent the best of that. It's been an honor to be in conversation.
Happy quarantining, everyone.
So be well and stay safe, everyone.